And we are back, folks, here on the Michigan Insider Sport. Oh, let me mute my mic. Give me a second. All right. Now we can go. And we are back, folks, here on the Michigan Insider on Sports Talk 1050 WTKA, online at WTKA.com. Sam Webb, Mr. Ira Weintraub on the other side. And every Friday here in studio, we catch up with our friend. Most of the time it's on StreamYard. I'm here. He's there at the law offices of Joseph A. Simon. But this is a special occasion. Like, Joe has to be in studio because this is one of those weeks where the convergence of sports and the law is so present, so relevant, and so in our face that we need our guy. We need the Silver Fox to walk us through it in person. So Joe made it over here to the studio this morning to walk us through there. And we're going to talk some Michigan football too, of course. But Joe, good morning. How are you?
Sam, I'm glad to be here. It's been a long week. It's been a difficult week. I know you've been doing double duty. So have I, actually, with my day job. But I'm going to do my best. I've had a lot of people reaching out to me on X and other things. I'm going to do my best to try to answer a lot of the people's the questions that have been offered to me and go through this with my best analysis. This is a part of what I do, Sam, but I do it mostly at the University of Michigan. In the what University of Michigan calls the ECRT process through Title IX. And so anyway, I'm going to do my best. Happy to talk about it.
All right, Joe, before we get started, tell people about the law offices of Joseph A. Simon, where you're located, and how they can get in contact with you.
Sam, we're a criminal defense law firm. We do nothing but criminal defense, from misdemeanor allegations up to felony allegations. Nobody ever thinks they're going to need somebody like me. And this is actually kind of a good example. You know, we represent a lot of students, and complaints can be made through the Title IX department there. We do that as well. We also offer the service of expungement of criminal history.
All right. So this Mel Tucker case is just wow, right? It hit like a ton of bricks for all of us out here Sunday morning. I mean, we had no idea. If you listen to the Michigan State press conference, they would have you believe that they had no idea about the details of this case as well. So the very, very first question for you, Joe, is to give us an understanding legally of what Michigan State could have known by the time the news report came out. Because I've read reports that said, hey, they could have had internal discussions and known the details of the case at least going back to July. Whereas, of course, we just had Larry on, and he said, well, legally, they couldn't have known the details. They were barred from knowing. The only ones that could know were Mel Tucker, Brenda Tracy, and their lawyers. So what's your understanding of what the leadership at Michigan State could have known and when?
All right. Well, we know that the general allegation was known in December because Michigan State has acknowledged that. Then they had the investigative process, which took longer than the guidelines call for. And on July 25th, an investigative report was concluded. Here's where I may differ from your previous guest. I am not as familiar with the Michigan State policy as the University of Michigan, but I can tell you that I did look at the policy. And in the policy, it says that notice to the university president and board of trustees, it says the Title IX coordinator or designee provides the university president and board of trustees with, and there's a list, but one of them says, copies of all final investigative reports and written determinations involving the alleged sexual misconduct of an employee of the university. That is not saying, by the words there, the final decision. It's saying the final investigative report. And we know that the final investigative report was was concluded on July 25th. And we know somehow information about that was circulated. So I'm not saying I know for sure, Sam, because I don't, that the university president and the board of trustees got that report. But I'm saying that the policy does seem to allow for that. And putting math together, somebody had knowledge, right? And then there was the leak. Now, I want to give you a couple thoughts on my thoughts on the leak. I know you have plenty, but we'll stop there. Hopefully I answered that question.
Yes. All right. So they could have known based on your understanding of that document that you just sourced.
That's right. That doesn't mean the privacy rules would be breached. It doesn't mean anything like that. But that is right from the policy. And it says, again, copies of all final investigative reports and written determinations involving the alleged sexual misconduct of the employee of the university.
So, Joe, their position is they chose not to know. This is one of the stories that is widely been reported, that they chose not to further inquire. Now, the rationale, I guess, is the legality of it, but we're shooting holes through that. So let's assume, for the sake of argument, that they know they could have known, and they're saying publicly that they chose not to do that. Why is that? Why would it benefit them? I mean, what's the upside of choosing not to go through the rigors of getting the details of this case? I mean, what's the upside of that?
You want to, I do think it's important when you turn this over for an independent investigation to keep that investigation independent and not be ever accused of any influence or any handling. You don't want it to look like an internal handling of an investigation. So I do think some buffer is not necessarily suspicious. But I want to talk about some of my personal anecdotes in dealing with this at professionals. Now, Sam, I've represented physicians at the University of Michigan, faculty members at the University of Michigan, where allegations like this come up. When an allegation is presented, the supervisors for those persons have to make determinations whether that person should stay in place in their current capacity. This doesn't have to necessarily get into the detail, and I'm not talking about the formal process of a Title IX investigation or what they call RVSM investigation. I'm not talking about that. There's nothing that bars an employee supervisor from saying, hey, tell me what this is about. I get calls from persons in that situation. Should I say anything? Should I make a statement? Sometimes people have to choose between what's in their employment interests and what's in their other interests for possible criminal prosecution or other things. What I am saying is I don't see anything that would have barred the athletic director in December from saying, hey, Mel, what's this about?
Exactly. I said, what?
Mel Tucker doesn't have to respond.
Okay.
He has a right to keep his mouth shut. But so does the university, therefore have a right to act accordingly. Now, even if they don't want to get in the detail, even if he said being advised by an attorney not to give detail, tell me the general allegation. Because if it is in the realm of sexual misconduct, and you have a faculty member, a physician, a coach around young people, that's a determination that the supervisor needs to make.
Who believes that didn't happen? Like, no one believes that didn't happen, right?
Sam, I was giving a long explanation for that conclusion. I can't believe that didn't happen.
Of course it happened. Of course it happened. I just wonder why they think this is a better, this is the lesser of two evils. You look bad either way, and they think it looks less bad to say, oh, well, we chose not to dig into this deeper. It doesn't look less bad.
All right. So let's go forward now. So that was December, right? So then there's the formal investigative process. And let's assume that the university says we should stay out of this and we should stay independent. Fine. That's good. When the investigative process concludes and there's a report, the next phase is for there to be a formal hearing. I just want to interject real quick. A lot of people think a decision and a remedy and a penalty is going to be imposed, if any, that day. That's not my experience. The hearing will be reflected. There'll be evidence taken, and then after that hearing, I would suspect a week or so or more later, you'll get a written decision and then maybe a penalty phase. But my point is, when the investigation concluded, if that report was in fact turned over to the president and trustees, I'm reviewing the privacy policy. I don't see anything precluding them from discussing internally without keeping all confidentiality in place, what they should or shouldn't do with respect to the standing of an employee.
Mm-hmm.
Now, to your theory on leaks, Sam, I just want to offer this. We all speculate, right? And
so let me give you my theories
yep,
for folks who
sure.
don't know. I mentioned this early, like Tuesday, right?
Mm-hmm.
Where I was like, look, I think Michigan State leaked this because Brenda had month. She could have gone public with this in December. She could have gone in the spring. She could have gone in July. She could have gone public at any time before Sunday. So why all of a sudden when she do this? And I was putting it together with some things I had heard that, hey, she started getting calls from media. And at that point she said, okay, well, let me get my side. And that made sense to me. Well, as we know, Brenda Tracy, her lawyer, they came out a day or two after that and said exactly what my speculation was, that, hey, someone leaked her name. She was getting calls. And so she said, you know what? Let me get my story out, my side of what happened out, and let the chips fall where they may.
So, Sam, let's put it all together and see what we can deduce from this. For information to be leaked, it has to be someone who possesses knowledge of it, right?
Mm-hmm.
That's easy to figure out. So that's a small pool. That's either the claimant, the respondent, that means Brenda Tracy or Mel Tucker, possibly their representation, or it could be those in the university who had knowledge. So, okay, that's number one. Number two is, what's the motive for the leak, right? What's the motive for doing that? A lot of people are speculating, well, hey, this is a good way to get out of the contract, which might be true. But also, Sam, I wouldn't dismiss the idea that this could be akin to a whistleblower type of thing. Remember the history that's gone on in that campus recently.
Mm-hmm.
And if somebody with knowledge is saying, hey, let's just assume this is true. This is known by the supervisors, known by the president, known by the athletic director, known by the trustees. Let's assume that's true. And here we have our coach still coaching games. This is not the right thing for us to. In other words, the motive could have been independent of the football contract. It could have been akin to a whistleblower saying something wrong is taking place here, and it needs to be brought to the attention.
Right. So a couple of things here. We'll get to Title IX versus RVSM and what the distinction is, or if there is a distinction, because this is Mel Tucker's contention. But when it comes to motive, I can't discount that as what you just presented as a possibility. But I tend to be a bit of a cynic, Joe. I think that this was or is seen by some as an opportunity. Was that the motive? I can't prove that mine is true. But if a part of the contract language is you cannot, basically saying you can't bring embarrassment to the university,
mm-hmm.
It strengthens your case for dismissal to bring embarrassment to the university, right?
Mm-hmm.
So it's like a self-fulfilling prophecy. He can't bring embarrassment to the university, but if you leak it out there publicly, he's bringing embarrassment to the university. So it might be embarrassing for you too in the short run, but you get out from under this albatross of a contract that we know Michigan State is mostly on the hook for. I mean, how long did they deny the FOIA request before it became real and understood that they are paying like 80, 90% of that contract? So that's what I believe. Do I know that to be the case? No, I don't know that to be the case. All right, we need to get to a break though, Joe.
Okay.
When we come back on the other side, it is Mel Tucker's contention that this does not fall under Title IX. This is not a Title IX case at all. If the RVSM policy and procedure mirrors it, why is it relevant then if it doesn't fall under Title IX? I wonder why he is drawing that distinction. We'll get to that on the other side and much more with Joe Simon.
Hey, Sam, as we go to break while Joe is here, should we open up his doors?
Yeah, we absolutely should. You want to come inside of That's where we do the Key Bank Countdown to Kickoff inside the Bud Light Victor's Lounge. We have a great time with our pregame show. It is food on us, drinks on us, atmosphere on you. If you want to come party with us leading up to the Bowling Green game, all you have to do is be caller number 7 at 734-998-1050. Again, 734-998-1050. Got to get to a break. Back on the other side with more Joe Simon here on the Michigan Insider on Sports Talk 1050 WTKA, The Ticket. We are still live, Joe, just to let you know, we're still live on the live on the stream here.
Well, for anyone who was at the lounge last week who could hear that, I'm not packing the jury this time, Sam. my people will not be there.
That was hilarious. That was hilarious.
I didn't know they were going to do that. That was funny. That was great.
Hey, but you got to be able to deal with that, right? You got to be able to deal with that.
And you acquitted yourself quite nicely.
Yeah, but the passage that I'm going to read on the air for people who are looking at watching us in the stream right now in the USA Today piece says Tucker also asserted that his case is not being handled under Title IX, a federal law that requires schools to address sexual harassment if it meets certain criteria, such as the incident took place on campus or in the context of a school program or activity. Michigan State's policy, however, uses a more expansive definition of sexual harassment, also covering the conduct that does not fall under the umbrella of Title IX. It provides virtually the same procedures for both, university spokesman Dan Olson said. So that he's saying that it is not a Title IX deal seems inconsequential to me.
Well, I don't know if you want to save this for on the
we can repeat it.
But it's a distinction that may not have a difference. It certainly doesn't have a difference to the procedure. The investigative process is the same exact investigative process. What I think he's doing is setting up two things. He made a jurisdictional argument that he succeeded on Title IX.
Yeah.
And he's trying to make the same jurisdictional argument on the RVSM policy. And by the way, it's not a bad argument because that last provision. So Title IX is excluded because it wasn't on campus. Or it wasn't part of a program.
And so, but this program, because he remember, the investigation found that he lied about where he was when the phone sex took place.
That's secondary to the jurisdiction question.
Why is it secondary to the jurisdiction?
The first question is, what are we doing here on this investigative process? Is it a Title IX or is it an RVSM? So on the question you're asking me, that was an RVSM investigation, not a Title IX investigation.
Gotcha.
Okay, but you're right to go there. But I'm just saying that's
I got you.
After that fork in the road.
Because there seemed to be some understanding that him being on an excursion, basically under the auspices, I'm the Michigan State head coach and I'm going to this golf outing, right? I fly on a private plane that I'm allowed to fly on as Michigan State's head coach. Basically, I'm on university business. I may not be on campus, but I'm on university business. So he lied about that. He said he was at home when the call took place. And that seems to me to be an admission right there that, okay, there is, at least for RVSM, they have jurisdiction here.
Yeah, well, okay, so that's the second question. So, right, so that one is any off-campus, outside of university-sponsored program or activity, but the conduct has continuing adverse effects on the campus or university-sponsored program or activity. So that can fill within that definition. So jurisdiction is one thing. The second thing is, I think his case for defending a termination under the contract terms is much, much, much weaker if he's found in violation of Title IX. If he's found to have discriminated or harassed on the basis of gender, that makes his case to plead much more difficult. If it's RVSM under sexual harassment, that's still not good if the finding is against him. But in terms of moral turpitude, he's making that argument already. This is my private life. This is what, it didn't affect the university, et cetera. It makes that more arguable.
All right. So a question I'm not going to get to on the air. We'll get back into that on the air. But someone just brought this up in the stream. And I thought about this. Would it have made a difference? I'm not saying you would ever advise a client to lie. But if he had said, I wasn't really handling myself, I was just having a conversation in the mood.
You should ask me that on air because This is an important thing. He doesn't have to say anything in this process. He can shut up.
So when the investigator came to him,
Yeah, that's right.
He didn't have to say,
That's right.
All right, here we go. We'll get into that.
All right.
Back on radio in 5, 4, 3.
And we are back, folks, here on the Michigan Insider Sports Talk 1050 WTKA, online at WTKA.com. Sam Webb, Mr. Ira Weintraub on the other side. Before we get back to the silver, man, it's so great to have Joe. Man, it's so great. So, folks don't know this. This is like my dude. Hey, well, if you listen to this show, you know Joe's my guy. This is like my dude. Just love just being around him. And it first became clear that, Rick's not Joe's only brother. I'm his brother too. When we start watching games together, and it's like, okay, yeah, this is my guy, Joe. So this is my guy. Always great to have him in studio. I want to let those of you who are in the market for a new vehicle know, get on board with Brighton Ford. Go to BrightonFord.com. Call 1-800-NEW-FORD. Make it out to the lot at 8240 West Grand River Avenue in Brighton, Michigan. 2 deals for you to be on the lookout for. The 2023 F-150. You can get into that award-winning pickup right now for $261 a month with $3,500 down, or $227 a month with $500 down. Or how about this one? That hot 2023 Bronco Sport, $228 a month with $3,500 down, or $355 with $500 down. For those and other great deals, get on board with Brighton Ford by going to BrightonFord.com. Call 1-800-NEW-FORD to make it out to the lot at 8240 West Grand River Avenue in Brighton, Michigan. So, Joe, you are our legal expert and insider, but that's just like a side gig. Your main gig is you are the best defense attorney in the area, right? So for folks who might need you, give them what you do and how they can find you.
You can find us at the michigandefenders.com or 734-887-6200. Sam, we do anything, all criminal defense, anything from misdemeanor, which includes misdemeanor traffic offenses, all the way up to serious felonies. We definitely represent persons on the campus. We do some ECRT work, Title IX work as well. And people all can get... this is kind of a good education, what we're talking about, because Title IX can include faculty. At the University of Michigan, we have a hospital, physicians. It can include students for sure. All of that is part of some of the work we do, but we do this in Washtenaw County principally, but all surrounding counties as well.
All right. So we're talking about basically the legal analysis of this Michigan State Mel Tucker case right now. So I'm going to read a passage from the USA Today piece. It says, Tucker also asserted that his case is not being handled under Title IX, a federal law that requires schools to address sexual harassment if it meets certain criteria, such as if the incident took place on campus or in the context of a school program or activity. Michigan State's policy, however, uses a more expansive definition of sexual harassment, also covering conduct that does not fall under the umbrella of Title IX. It provides virtually the same procedures for both, a university spokesman told Dan Olson. So you mentioned RVSM, Relationship Violence and Sexual Misconduct, that policy. He's drawing a distinction here. It does not seem like a distinction that helps him in any tangible way. Why draw that distinction, and why wouldn't this fall under Title IX?
I think it could help him in the end result. It doesn't make any distinction whatsoever in terms of the investigative process. So if you think of this as a fork in the road, when a complaint is made, the determination is, does the university have jurisdiction to hear the matter? And it's A or B. It's if it's an allegation of this nature. A, we have jurisdiction under Title IX, or B, we have our RVSM policies. If A, then the procedures, in the investigative process is exactly the same as B. So in that regard, doesn't make much of a difference. But he is making a jurisdictional argument as to both. Apparently, what his attorneys are saying now is, look, we prevailed on the Title IX thing. We'll come back to that. We'll put a pin in that. We prevailed on that. This is not a Title IX thing. And looking at the policy, there are jurisdictional requirements, but one of them being that this had to happen in the context on campus or in the context of a university program or activity. So maybe that's the reason he prevailed. The second thing, he's also still not given up on the RVSM jurisdiction, which has a little bit of a broader provision on sexual harassment. It says it can include off-campus or outside a university-sponsored program or activity, but the conduct has continuing adverse effects on the campus or a university-sponsored program or activity. That one I also want to put a pin into. So let's go back to program or activity. Was this on the campus?
No.
Was it a part of an educational program or activity? You could try to stretch the argument on the golf thing, but the conduct, Sam, the conduct, was it part of a program or activity? No, I don't think so. And I think that's why Title IX wasn't at play. But let's go back to that other pin, which is the conduct has continuing adverse effects on the campus or on a university-sponsored program or activity. This is the hook that he's still arguing, but this is why we're here, I believe. Now, let me just go to the end game, the ultimate thing of what you asked me. Why would it make a difference? If he's fighting over his dismissal and the terms of that contract and a broad term like moral turpitude, which is not defined in his contract, Sam, I think he's got much less of a fight if there's been a finding by preponderance that he violated Title IX and discriminated against someone on the basis of gender. Much less of a fight. If it's the other finding, it's more arguable for him. And I think that's why the distinction is being insisted upon.
Okay. Well, it would seem to me, and let's get into the, what is harassment, right? And so his claim is this is not harassment, that this was a consensual relationship. I'm not passing judgment on that. I told you there's a lot you read here that kind of leaves you with a lot more questions than answers about what their relationship was. I have no idea what their relationships was, and I have questions about it. But it seems to not matter, at least in the context of whether he should, keep his job or get any money now that it seems inevitable that he's going to get fired. Because in a way, isn't she a subordinate? I mean, she is contracted to do a job with Michigan State University. And the reason she has that contract is because of Mel Tucker. The reason she wasn't able to come back was because of Mel Tucker. Seems her employment, while not being a direct employee of his, her work with the university is contingent upon Mel Tucker. So is this not a subordinate, a power position that he's in as the head football coach at Michigan State?
This is not an easy answer. I mean, I know that today people would want me to say quickly, oh, yes, absolutely. But I'm sorry, it's a little more gray than that. Let's go through some history on this. Do you remember when we were talking a couple of weeks ago about hazing, Sam? Remember when we were only talking about things like that?
Right.
and I said to you, Sam, interestingly, hazing, there's no consent defense to hazing. It's specifically excluded. And the reason for that is because consent can't be freely born in an environment like that. If you want to be a part of the team, for example, or part of the fraternity, you can't really freely say no. It's a compromise situation. That is the root of the question you're asking me. In a power imbalance where somebody has authority over somebody else and uses and flexes that imbalance in subtle or direct ways. Let's go to the obvious. A direct way was, hey, the teacher says, you want a good grade on this test here, young person? Okay, that's the obvious way. That's extortive. That's easily understood. But it also can be subtle or things that are implied. So that's what the root of that, because consent isn't freely. I can't think of the fellow's name in Hollywood, the casting couch guy I'm blanking on his name. I apologize. But the same idea. Harvey Weinstein. Thank you so much. The same mentality that consent can't be freely bestowed there. So in this situation, is she Mel Tucker's subordinate? I would argue that if I were representing him, no, I don't want anyone start, as they say, adding me on this. I'm just going to present the position that no, not really. She's a contract employee of the university, that she's getting paid by the athletic department and the university, that he has no direct supervisory role over her, that she doesn't answer to him in any way, and that imbalance doesn't exist. That is an argument that has credibility. Some arguments have no credibility, Sam. And that's going to be a debate here. So it's a little different. And I'm not saying that I am picking a side on this.
Yeah, listen, I think what the relationship was is something that is going to be litigated in the RVSM way. And we're going to get to your thoughts on what that kind of litigation looks like. I'm not even talking about that, though. I wonder if that's relevant to the ultimate outcome. Here's why I ask that question. Consent seems to have been admitted to in the Ime Udoka case, for instance, right?
Mm-hmm.
So Ime Udoka had a relationship with maybe not a direct subordinate, but someone that's lower on the flow chart than him, and he was dismissed as a real workplace power dynamic imbalance. Got him fired. And it seems to me that the same thing could be argued here, even if consent were conceded here, which it's not. I mean, she's saying it wasn't consensual, but let's assume for the sake of argument it was, Joe.
Right.
Then it still seems like he has some exposure here. Now, what her attorney is going to argue, I'm no lawyer. She's like, no, there was a power imbalance here, and he used it. You know how he used it? Because when she tried to come back for another address of the team, which had been agreed to, all of a sudden, no, we can't get you. We can't fit you in the schedule. You know, there was some research done, and it turns out there was no conflict on the schedule. And so they're going to assert that, see, this is him using his power to affect my employment because I wouldn't go along with the relationship that he wanted me to go along with.
That's absolutely right. And if that were true, that would be true. And what I mean by that is consent, the power imbalance exercise of it has to be at the time of the act. So if she says I was harassed and denied opportunity after that April call, I think it was April, because I wouldn't adhere to his requests, that could actually be another basis of another claim. You know, but a lot of what we're talking about now, Sam, is addressing some of the credibility arguments that are going to be made against both of them. They
are. And, like for instance, just real quick, they talk 20 times, 20 plus 27 times over a half an hour late at night. That's why you ask, like, what was this relationship? That's why I'm not passing any judgment on that part.
And I don't think we should, right? But to the ultimate point that everyone's going to is, by his admission, is he vulnerable and likely gone anyway by just what he acknowledges? And I agree with that. But it's funny about admissions and credibility, Sam. Did he have to make an admission here?
This is a key question because, again, I want to stipulate, I'm not asking you, would you ever advise your client to lie? I'm not asking you that. But it seemed to me, just on the, Joe off the street would have some street sister, don't overshare. Like, you had a right to remain silent.
You do.
But even if you don't remain silent, do you have to acknowledge that you actually that you were actually doing what you said you were doing at the time? Or could you have said, I was just having a conversation. We were having a talk, really suggestive talk, but I wasn't really doing it. I was just responding in kind to the kind of conversation she was having.
Mm-hmm.
But that's not what he did. He said, oh, yeah, I did. You know what he said.
So Sam, first of all, you can ask me that question about would I ever advise anyone to lie? Absolutely not. I have two ratings, Sam. One is for the highest legal abilities. The other one is highest ethical standards. And I'm proud of both. You can never, lawyers may do it, but you're not ethically supposed to advise anyone to lie ever. But yes, he's got an absolute right to shut up. In fact, in fact, he doesn't have to participate at all in the process. Everything about this is voluntary. I want a quick sidestep here and address some of the things people have been asking me. Oh, can't they get his phone and search it forensically or whatever? Everything about this process is voluntary. There's no subpoena authority to bring a witness. All witnesses' participation is voluntary. There's no subpoena authority to get documents or other evidence. There's no other investigative process that allows that. It's all voluntary, including his participation. Now, the policy specifically says that no inferences or assumptions shall be withdrawn from a party's decision not to provide a statement or even be interviewed.
Mm-hmm.
Now, that they still can decide on the evidence they have in the absence of evidence on the other side, but just the fact that someone chooses to remain silent can't be drawn. Now, let's talk about the admission.
All right, so let's pause here.
Okay.
Let's pause here, and we'll come back on the other side, and we'll wrap this up. We'll get a little bit of Michigan, and we'll wrap this discussion up. People need to understand. I remember when we went to Joe with the premise of this appearance, like, would there really be? I mean, sports and the law, it's guys with that. I mean, why do you need a legal insider, an expert? Is there really going to be a lot to talk about? Yes, Joe. I'm telling you, there's going to be a lot to talk. And here we are. So when there is a convergence of sports and the law, we bring our legal expert on to give us the legal opinion, which is a lot different than some of the media representations of what's going on. So Joe coming in to fill that need. We'll get a little Michigan football in on the other side as well here on the Michigan Insider on Sports Talk 1050 WTKA, The Ticket.
Clear on the radio.
All right, so Joe, some things that we won't have time to get into on the air that we can maybe address here. So Mel Tucker, he gets dismissed.
Mm-hmm.
He's gonna if they don't settle, right? Which it seems like Michigan State. Larry was saying, hey, if they want to fight this tooth and nail, they're making the decision on the moral turpitude clause.
Mm-hmm.
Like they're the judge and jury there.
Yeah.
So it seemed to me they can get out of this contract. If he sues, does he have a case? Does he have a legit case?
Absolutely. Look, absolutely he does. I mean, that's an ambiguous term. They're the judge and jury on the contract, but it doesn't mean that legally it'll necessarily. A lot will depend on these findings, but absolutely he's going to sue, and absolutely he's got a case. Look, there's going to be quite a nuisance cost to the university to fight back on this. So, is it in their interest to make a settlement? Yeah, to avoid that. But sure, he's going to sue. Why wouldn't he sue? He's got too much at stake. Well, he got too much at stake, 90 million or whatever it is. Why wouldn't you? Sure.
Yeah. So, to avoid further embarrassment or dragging this out more, you think they might do it. The investigation into
can I ask one more thing?
Okay.
In such a lawsuit, the discovery powers are very broad. If the defendant, a party, is this university, we get the answers to the questions we've been wondering about. That's another thing the university might want to sidestep. There's a lot of deposit. Who knew what? Who said what? When did you know it? Who got what?
So to avoid discovery, just give him his money. Yeah. Okay, that's an angle of the of why it would be, in their best interest. Just go ahead and settle this.
Yeah.
For a lot less than they would have paid him if he was still coaching. But part of this you have with the trustees. One of the trustees just came out and said, hey, we need to investigate this leak. And there seemed to be some indirect acknowledgement that it came from them. Like they apologized. That's like a tacit admission almost.
If that's true, that supports the policy thing that I discovered, that the report would have gone to the president and the trustees.
Mm-hmm.
That's some further support of that.
Yeah. So what would an investigation like that, what would it entail? I mean,
it would get the full report. Now, I think the policy also says the names have to be blacked out. So her name would have been blacked out and redacted, but they would get the full investigative report.
Yeah, man, this is God. You talk about the galactically stupid. I just don't know how.
Yeah.
Don't know how you put yourself in this position. You just would think that he'd be a little more on guard than he obviously was. Even even if it were consensual on the phone. Like what? It's like, this is just not bright. This is just not bright. But when we come back on the other side, the very last thing that I want to address is, so we can get in the snippet of Michigan, is this process.
Yeah.
You know, he called it a sham process.
Yeah.
And so I want your legal opinion on the Title IX / RVSM process and how it differs from an actual legal proceeding in a court.
Yeah, Sam, I'll be happy to talk about that, but we got to talk about that admission. I want to say one thing about that. Yep, one thing about that.
All right. We will get into that for sure. How much longer left in this break, Mr. Weintraub?
You want me to do math? About 30 seconds.
All right, 30 seconds. I will say this to kind of set up a conversation that we're going to have in closing. I told Joe that he wasn't going to get everything he wanted on the football field from the office, but you get it piecemeal. And Joe, you got 3 option routes, man. You got 3 option routes in the game Saturday.
Sam, live time. I've not gone through the film. Live time. I was talking to my brother. You know how he avid fan he is, and I told him, I said, I think I just saw the tight end sit in an option route. And Sam, let's not have fake news. I called for 1. I said, let's just put 1 out there.
All right, here we go.
Back on radio in 5, 4, 3.
And we are back, folks, here on the Michigan Insider Sports Talk 1050 WTKA, online at WTKA.com. Sam Webb, Ira Weintraub on the other side. Our legal expert and insider, Joe Simon, is in with us whenever there is a story of sports and the law, which is all the time. Like we told you, Joe. Joe comes on and he separates the wheat from the chaff. He tells us, separates the real from the fake, like he is doing with this case up at Michigan State this morning. So a few more things before we move on and get a little bit of Michigan here. You said you had one more thing to kind of put a bow on the admission conversation.
So we talked about how he didn't have to participate. We talked about how he didn't have to make a statement, and he made that admission. And you know, Sam, that's funny. When a person makes an admission like that, when we go to the credibility issue, if somebody is acknowledging a very severe negative thing to their own behavior, it has an implied boost of credibility.
Mm-hmm.
So, you know, people could lie, or they could remain silent, or they can tell the truth. The fact that he readily acknowledged the conduct is in part damning for him, but it's also in part bolsters some credibility. That's how I would use that in a courtroom. If a client of mine made an admission like that, I would offer that in support of truthfulness.
Yeah, and then on the other side of that, though, he lied about where he was when he did it.
So let's talk about that, because it's going to go to your question, the investigative process. You know, a lot of this process is frustrating, and some of it is going blind. In other words, you don't know the other side's evidence or statements until you get presented that. So people can make mistakes. So in other words, that was rectified by a phone record, I think, that she provided. He didn't have that in advance. So it could have been a lie, could have been just a mistake. My memory was on, oh my gosh, now it's corrected. But it's part of the frustration of this process, was what you're going to ask me next.
Right. So the process, Title IX, RVSM procedures are largely the same, right? So how does that process differ from a legal proceeding in a courtroom?
Let me give some historical perspective on this first. This all stems from the Department of Education and their policies, and we've had a lot of turnover in the Department of Education with different administrations. These policies change. They change dramatically because of policy turnovers, administration turnovers, and also because of lawsuits. Sam, I've been doing this for quite a long time. I've watched this where they had no right to an attorney. I've been in situations where I've been able to be an advisor, but not an attorney.
In a Title IX procedure.
In a Title IX procedure. No right of cross-exam. Cross-examination, Sam, is a relatively recent right. I'm going to tell you how it works at Michigan, and now it may be reversing again where you get denied that right. At the University of Michigan, here's how cross-exam works. Every single question has to be vetted by the hearing officer. and then approved.
Are these hearing officers lawyers?
Yeah,
Judge?
by and large, lawyers,
Okay.
sometimes retired judges, but yes. But every question. So if I say, Mr. Webb, how are you today? The hearing officers say, you may answer. And you don't answer until that. Every single question. Now, as a guy who's a cross-examiner for a living, I always talk about the rhythm of cross-examination. You've got to be effective at it. You have to have that rhythm and get a cadence is developed, and you move along through that. And that's so disrupted in this proceeding. Discovery, as I mentioned early, is everything's voluntary. If I want a witness, I can't compel a witness. A witness has a right to opt out. If I want information from the other side, I don't have a right to get it. These things have historically changed. It is one of the most difficult. You don't want to be in one, Sam. I'm going to tell you right now.
Well, it used to be that it wasn't. I mean, it seems like progress to me that you even have a lawyer or a judge overseeing the proceeding, because it used to just be like a professor or university official.
When I first started doing it, was a student panel. It was a panel of students. So let me say this to you, Sam. It is a very difficult proceeding, and the burden of proof has changed over time as well. So this particular process, what we can know, because I've looked at the policy, there will be cross-examination. The burden of proof is preponderance of the evidence. Sam, in the law, burdens of proof are not very defined except this one. This one is 50% plus.
So if it's more likely than not that you did it.
That's correct. This is a defined burden of proof. 51%, even like 50.0001% is enough. And that standard has changed over time as well. Like, for example, in a criminal case, we have proof beyond reasonable doubt, not a defined standard. Some people say 90%, 93%. It's not a defined standard. So it is, is it easy to be a litigator in a proceeding like this? No. Is it easy to be a claimant in the case like this? No. Is it easy to be a respondent in a case like this? No. It is a very difficult process that does not have the protections that are generally afforded in a court proceeding, civil or criminal.
Last one. You think there's a settlement agreement that comes from this from Mel Tucker?
Something's got to come from it. I think that there's an interest from both sides. If he gets discharged, of course he's going to make a claim against the university. Of course he's going to challenge it. And in the end, yeah, I do think that's the most likely scenario.
Yeah, something you said in the break, discovery will be a part of this if it gets to that point where there's a lawsuit. So does the university really want to expose itself in that way to who knew what when? And
so let's be clear. If he sues the university is a party to the lawsuit, and that means he has a right to depose, send interrogatories, compel documents, who knew what, when, what did they get it, etc. Exactly right. The questions that you and I have been speculating, he gets to have answers to.
Yeah. All right. Let's get off of that. Get a little bit of Michigan football in, Joe, because you come on here and give your opening statement, right? Your opening statement for the case that you're going to present in detail tomorrow inside of Joe's garage. So a little reflection upon last week and your opening statement for this week.
Well, I didn't prepare an opening for this today because I was busy getting work prepared for this, but I'll give it tomorrow in the lounge, and I will not have a packed jury in the lounge tomorrow, Sam. Last week I was stacked, but I have some things to say. So, I want to correct the record. Remember when we started this season, I said I have a threshold question, Sam. My threshold question is with all our returning experience and our depth with JJB and QB1 and a full spring and fall, what was the plan for the offense this season? Was it to do that which we've done only better, or to expand? And I argued we needed to expand to get to the next level. That was the premise of my argument. And I was specifically for calling for certain concepts in the passing game. It is a little fake news to say I was calling for the kitchen sink. We have podcasts, Sam. I never called for the
Hey,
kitchen
man.
sink. I said we need to introduce some elements. We need to put them on film, and we need to get some game reps. And guess what happened after last week, Sam?
Yeah.
I called 1 week ago, right here. I said we need to get some option routes. I said, Sam, do you agree with me that we can do that? We have that chemistry and experience. You said yes. I said, well, can't we put one of those in the game? And guess what happened, Sam?
Three of them in the game.
3 of them.
Yeah,
and
man.
that's a good thing. And I also think it's important to continue that arc. I think we do need to game rep some elements in that regard. You know, this week, Sam, we had 2. Remember how last week we talked about things that are said that I use in my arguments?
Right.
I had 2 more gifts this week, Sam.
Yeah, man.
2 more.
For those who don't know what he was talking about, Devin, who's our Monday morning
Who's
quarterback.
Devin? I only say I'm playing because I heard when my name came up, he said, who's Joe Simon? So
You gotta watch the show. All right. So, Devin said elementary concepts with graduate level execution. And he was speaking of that in a complimentary way. He was mentioning it as an attribute, as something to celebrate. Joe was like, see, Devin agrees with me.
No, that's not quite right.
Okay, all right. What did you say?
He agreed. There was agreement. The agreement was that's what we have been doing. I was calling for more. That's my departure, saying more is necessary. I think what you would say is he would say more isn't necessary. Maybe that's so until I heard, let's see, you and Devin, I think I heard another thing, which was more complicated things are coming. And you know what? When they come, that's going to open up the basic stuff even more.
I've been saying that all along.
No,
didn't I? My case that I presented is that the install, the offense is going to be like a staircase.
Oh, no, you're fine with that.
You're going to build every week.
I agree. But Sam, doesn't that help my case too?
I told you that from the beginning, Joe.
Okay, wait. One more thing. I heard Coach Harbaugh say to Jansen in his podcast this week, glowing about Scott Loeffler and their passing game. He said, boy, I got to steal some of those pass concepts. We got to get some of those in our offense. Here's the point, Sam. The point is simple, that I hope it's true that we're going to introduce more of those elements. I really believe it's going to be necessary. Look, when our running game is experiencing difficulty, is it important to work on the perimeter run game? Absolutely. Is it important to further deploy the passing game? Absolutely. But when we face a team that's capable to check us on the line of scrimmage without extra bodies, again, I keep going back to Georgia, which isn't fair because that was an NFL team, but just a team that has that capability and can match up pretty well with us in the defensive backfield. My simple point is, why not flex that muscle that you have with that added chemistry and experience? And I'm not saying that tomorrow we put everything we got on tape. I'm saying that put another element in there, send some fear to some defensive coordinators. I mean, we have things that we can be doing.
I'll say again, Joe, you don't get to the 10th floor in one step. It's a step every week. Add it every week. And that's what we saw, some additions last week. We'll see some additions this week. They'll get there. We'll close this way with a surprise for you, Joe. So we're going to have to kind of get back in. We've largely separated the Michigan State discussion from the rivalry.
Right.
Let's throw it back in. We're going to be having a Michigan State beatdown party over at Black Rock Bar and Grill. So I'm just saying that to everyone listening. All the people on the screen.
It's going to be the best beat Sparty party we've ever
had. I mean, the food is great. The TVs are great. The venue is great.
We get to sizzle steak while we're broadcasting.
It is going to be off the charts. And if you want to be around, I hope you're around, Joe, so you see how Joe and I get down on game day, doing the back and forth. This will be that time. So mark your calendars. If you aren't going up to the belly of the beast and you want to hang out in a party atmosphere,
it's safer at Black Rock.
Get ready. We'll be giving you all the details in the days and weeks to come about our beat down Sparty party coming up. Next month, whenever
October
that game
21st.
is. October 21st.
See, it's really interesting since you mentioned that game. I think we're going to learn pretty much everything we need to know tomorrow about Michigan State. I mean, to state an obvious point, they go in one of two directions, don't you think, Sam? Either this earthquake, if you will, sends them in disarray, or it really galvanizes them and they have some kind of special season.
Yeah.
And
I don't think they have a shot in hell in this game.
Well, I'm not saying they do.
I know you.
I'm saying that things happen in the course of a season that can cause a trajectory. And I think tomorrow we're going to learn a lot about Michigan State and what that rest of the way is going to look like.
Look, I'm actually not wishing this upon them, but I see no inflection point. I thought they were going to suck before this. And I think they're going to suck worse now. So,
Sam, I often say this about you. They bring out the best in you. Ohio State, obviously, as well. But they bring out the best in Sam Webb. The dog in Sam Webb.
It comes out, no doubt. I might have to tame it a little bit this year, though. All right, so, Joe, before you go, tell folks about the law offices of Joseph A. Simon. One guy said, hey, can he get my open container deal off my record?
I can help with that. Absolutely. In fact, let's talk about that. Game day offenses is absolutely a part of what we do. And people don't realize this. Adult, minor, it's the same thing. If you have an open container of alcohol in a public thoroughfare in Ann Arbor, that is a misdemeanor. And yes, we can help with that. Do everything from misdemeanor to serious felony. TheMichiganDefenders.com or 734-887-6200 is the number.
All right, Joe. See you tomorrow, man.
I'm looking forward to it, Sam. It's going to be fun. We'll put this more serious stuff away. Well, not that Michigan football isn't serious, because that's serious to all of us, but we'll have some fun tomorrow on the lounge.
All right, folks, we got to get to a break. John, you bacon on the other side here